Hi everyone, this is the Refingers seminar on general data protection, commonly known as GDPR. We're happy that you joined us. It's pretty cold outside, so you wrapped up and have a hot coffee or tea with you. Hopefully over the next 30 minutes, you will find out a lot more about GDPR. My name is Sudha. I'm one of the partners here, and I've got Mehul here, who's one of the associate partners. To start with, a little bit of housekeeping. We have got no fire drill planned here, so if you hear the fire alarm and we are running, we're actually running for our lives here, so just bear that in mind. To avoid any background noise, we got you on mute, so if you've got a question, you will see either at the top or the bottom of your screen a Q&A button. Press that and a little window will open up. Type in your question and send it to us. We'll try and answer as many as possible at the end of the webinar. We've already got some questions and we'll start off with that. One final bit is the presentation. We will send you a copy of the presentation either early next week or later in the week next week. Just quickly, I'll give you a brief background to us both here, myself and Mehul. Myself, I look after a lot of the SMEs in the firm and advise companies on systems and IT related matters. I also oversee the firm's IT, and I work closely with our IT manager in implementing the firm's GDPR. Mehul here works on audit, accountancy, and tax services, and he's our GDPR specialist. He is also the firm's data protection officer. Later on in the presentation, we will talk about when you need to appoint one. I'm hoping that recruitment companies don't really need to have one, but we'll talk about that a little bit later. But I'm going to hand over to Mehul to do the presentation now. Thank you.
Morning all. So what is GDPR and who does it apply to? So what I want to do is kick off the webinar just with a bit of background about GDPR and where we are today. And then also, as we progress through the webinar, we're going to be touching on a lot of the general principles and how they apply to recruitment companies. And overall, this webinar should give you a good flavour and introduction to GDPR to allow you to start planning your GDPR approach up until when it comes into play next year. So GDPR will apply in the UK from 25th May 2018. And an important point to note that the government have confirmed that the UK's decision to leave the EU and essentially the current Brexit negotiations will not have any impact on the commencement of GDPR. So as far as we're concerned, it's business as usual. Now, who does the GDPR apply to? Well, Article 1 of GDPR states that the regulation lays down the rules to the protection of natural persons regarding the processing of personal data. So in layman's terms, what does that actually mean? Well, what it does mean is that GDPR applies to individuals and not companies. And an important point that we want to talk about is the controllers and processors principle. So GDPR applies to both controllers and processors. And the definitions of controllers and processors are broadly the same under the old Data Protection Act. A controller says how and why the personal data is processed. So essentially, this is the owner of the personal data, the individual or the company who has collected that personal data from the data subject. And the processor then acts on the controller's behalf to actually process this data. Now, examples of this include payroll providers, IT support, IT hosting, that sort of thing. Now, one thing that's mentioned in GDPR is that if you are a controller, you aren't necessarily relieved of your obligations where a processor is involved. In fact, GDPR places further obligations on you to ensure that your contracts that you have with your processors are compliant with GDPR. So essentially, what you need to make sure is that if you're a data controller or a data owner, you will remain responsible for the service provider's data processing and any breaches that they go into.
Yeah, we are an accountancy firm at Refingers. We are both controllers and processors. Same will apply to some of you recruitment companies out there. You could be a controller and processor. Give us some examples of controllers and processors, Mehul.
So an example would be, say, for example, you've got a company, say a recruitment firm that has collected loads of candidate CVs. You've got a lot of candidate CVs on file. And then you engage with a online search company or online CV library to then essentially put these CVs out there for these individuals. So that other recruitment agencies or other recruiters can then come in and look at your candidates. So essentially, you were the primary contact in collecting that personal data from your candidate. So you are the controller, essentially the owner of that personal data. You've then engaged with an online search provider or an online CV tool, and essentially they will be processing the data on your behalf. But like I said earlier, that doesn't necessarily relieve your obligations under the GDPR. That actually places more obligations on you to ensure that that contract that you have in place as a recruitment company with the online CV tool and the company behind that is compliant with GDPR.
Yeah.
So moving on to the next slide, I just wanted to actually talk about what type of information that GDPR applies to. Now, if you see on our side at the moment, GDPR is really split up into two specific areas in terms of personal data. You've got personal data where it would be things like CV information, and CV information can be things like names, addresses, contact numbers, bank details, and sort of employment history. And then on the other side, you've got sensitive personal data. Now, sensitive personal data can be things like genetic and biometric data. And I think for a lot of recruitment companies, you're not necessarily going to be collecting sensitive personal data. Now, one of the key things to draw upon here is that the definition of personal data and sensitive personal data is essentially very similar to what it was under the old Data Protection Act. However, it's a little bit more expansive and it's a little bit more detailed. And what it does mention in the actual regulation is that things like online identifiers, such as an IP address, can classify as personal data. And so I suppose the expansive definition has arisen out of the way we progress as a society in terms of technology. So what GDPR is trying to do is just catch up. So the old Data Protection Act was very historic and it wasn't necessarily very relevant to a lot of the new trends that we're seeing with things like LinkedIn nowadays. And we'll come on to that later in terms of the specific points over social media. But essentially GDPR is now catching up in terms of the type of data that we have out there that we're using.
It's very interesting. Sensitive personal data. It's a bit of a mouthful. I'll just read it from my note here. Actually, genetic data and biometric data normally means data related to physical or mental health of a candidate. Now, I mean, the key is, do you hold that kind of data within your CV database? Why do recruitment companies need to hold that kind of data, about somebody's physical ability and mental?
Well, it's interesting because a lot of employers that you act on behalf might want you to find out this information on their particular candidates. And it's not unheard of where, I suppose, particular employers want to know as much as they can about their particular candidate and the individual that they're employing. And so therefore, you might be in that situation where you're collecting this type of sensitive personal data. Essentially, what you need to do as a recruitment company yourself is to make sure that you mitigate the risks that you have in collecting this type of data, making sure you've got the relevant safeguards and precautions in place to ensure that this data is well protected. And when you don't necessarily require it, is ensuring that you can delete and get rid of the information if you don't necessarily require it. Moving on to the next slide, I just want to talk about the GDPR principles now. I don't want to spend a lot of time here because, as you can see, we've got them listed on the slide there. The only change that we've seen from the old Data Protection Act is this new accountability principle. Otherwise, the GDPR principles are as they were under the old Data Protection Act. Now, the accountability principle, essentially what that means is that as a person who's involved in GDPR, if you're an individual or a company, you need to require that you demonstrate that you comply with the principles and explicitly state that it is your responsibility to comply with these principles. So essentially what you need to make sure is that you apply these GDPR principles as you did under the GDPR and under the old Data Protection Act, and then going forward, ensure that you show that you're accountable for these type of principles. Moving on to the next slide, and something that we've discussed ourselves a lot as a firm, and something that we've had a lot of questions over in terms of, as we've been conducting these type of webinars, we've had a lot of emails from individuals who've been asking us, how long should we hold our personal data, or is there any specific minimum or maximum time? Well, the GDPR Act does not set out any specific minimum or maximum periods for retaining personal data. Instead, it says that personal data that is processed for any particular purpose should not be kept longer than is necessary for that particular purpose. So essentially, as a recruitment company, what should you be doing? Well, what I think you need to do is actually review the length of time that you keep personal data. So is it necessary for you to hold someone's CV for 5, 10, 15 years? And then moving on from that, securely delete information that is no longer needed for that particular purpose or any purpose that you hold it for. And finally, you should look to update, archive, and securely delete any information that it goes out, as it goes out of date. So these are sort of the 3 steps that I would take to ensure that you're keeping your data up to date and making sure that you're not necessarily holding older data when you shouldn't be.
Right, that's very interesting. We as an accountancy firm, HMRC requires us to hold the data for 7 years. So we have to hold the data for 7 years minimum. So that's one of the requirements that we have, which we will be carrying on doing. I mean, recruitment companies, how long do they need to hold the data for? what is the situation with them? It's going to be different from candidate to candidate, isn't it?
Yeah.
Not all candidates you're going to hold data for, I don't know, 3-4 years.
Yeah, it just depends really, because we looked at the example. Say if you placed someone into a role 10 years ago and you had their CV at the time, and then just the way your systems are designed and the way that your processes are done, you still hold that CV on your system. And you have their contact details also, be it the name, the email address, telephone number. And every year or every 6 months, you have one of your agents contact them to see if they're still happy in their role and if they're looking for anything different. At the same time, on a monthly basis, maybe you send out some sort of marketing email. Now, I suppose what you've got to look at there is what information do you actually require? You only require the actual contact details. There is no requirement for you to hold that CV that you collected 10 years ago when you originally placed them in that role. And so therefore, what I would say is that in that sort of scenario, you should look to delete the CV from your system and make sure that you don't hold that information, because it just places more risk on yourself as a recruitment firm, and only hold that contact detail for them, be it the email address or the telephone number, in order for you to get in contact with them for any future correspondence. So it's just really judging as a firm what type of data you hold, whether it's relevant, and making sure that for the purposes of going forward and performing your contract and performing your role as a recruitment company, that you hold the right type of data.
The key is do not hold information longer than is necessary. That's what you need to take it from this. Is do not hold information longer than is necessary, isn't it? That's correct.
Yeah, exactly. Yeah. And now moving on to the next slide, just the conditions for using personal data. Essentially, under GDPR, what it does say is that you need to satisfy one or more of these conditions in relation to processing personal data. Now, I don't want to sit here and speak about all of them just because of the limited time that we have available. What I want to do is just talk about the two that are, I suppose, more important, being consent and legitimate interest. So the first and last bullet point on your slide. Now, consent essentially means that if you've got consent from the data subject to process their personal data, that's good enough for you to do so. So, for example, as a recruitment company, when you first meet the candidate, are you sitting with them and collecting all their information in the questionnaire? And when you've done that, do you get them to sign some sort of engagement terms or some sort of acceptance that you can then go and use their personal data? I think that's where you need to really judge your processes and systems, because you need to ensure that in terms of performing your role and looking for a job for that candidate, you have some sort of consent in place from them to use their personal data. And what's quite interesting, and what we'll come to now, is in terms of looking at two different areas for I suppose, the social media side of things, but firstly in terms of sending out marketing emails. Now, sending out marketing emails or general emails, I suppose, to candidates and prospective candidates that you don't know at the moment, it's not actually governed by the GDPR. It's governed by something known as the Privacy Electronic Communications Regulation, or it's more commonly known as PECA. Now, the rules are quite different for sending out emails to individuals and corporate bodies. Now, for sending out emails to individuals, you require consent. So this can be by way of a soft opt-in. So when you first get their contact details, you actually ask them at the very beginning to say, can we send you some sort of email correspondence? And then when you send them that email correspondence, and as you progress through that relationship with them, you need to ensure that you give them the chance to opt out and unsubscribe. Now, this can be implemented by including a link or a note at the end of each email to say to them, do you wish to opt out or unsubscribe? Now, where it gets quite interesting is where you've got corporate bodies. Now, as I mentioned at the beginning of the webinar, GDPR is not actually applicable to companies and corporate bodies. However, what happens when you send individuals emails who are at corporate bodies? For example, John Smith at XYZ Limited. Now, my opinion with this is that you should really be following the approach that you do for individuals. There is no particular consent required for this, but I think it would be best practice to follow the same approach as you do for individuals. So ask them for consent at the very beginning. So ask them to opt in order for you to send them emails. And as you progress to send them correspondence and emails, you give them the option to actually opt out or unsubscribe. So I think overall you can see it's quite acceptable to send the emails that you do, but you're just giving the option to that individual to actually opt out from that.
Yeah, as a general, social media has changed the whole playing field. The main reason for this introduction of GDPR is because exactly of that. Social media has changed it. Take, for example, LinkedIn. We talked about that within the firm as well. All of our staff here have got their details, email addresses, their work history, everything's on their, everything's on their LinkedIn profile, basically, isn't it? So how does that work? They've given consent already to use their email address?
Yeah, I think it's a very good point that Sudha raises, because we've talked about it a lot internally. So as a recruitment agent, you're going to be on LinkedIn, you're going to see individuals' employment history, and you look at it and think, oh, great, this particular individual is very suited to the type of role that you've got. Now, if they put their email address or their contact details on LinkedIn or any other type of social media, as far as I can see, in my opinion, is that they've given the consent to their wider network, be it their friends or their contacts within their network, to contact them and actually talk about their work history or talk about any particular employment details that they have on their profile. So essentially, we've seen scenarios where we've had recruitment agents call our guys up because their details are on LinkedIn. Where it gets quite interesting is where an individual will put their employment history on LinkedIn and their profile on there, but they don't put any contact details on, so they don't put an email address or a telephone number. And what we've seen in our own personal experiences, we've had recruitment agents call up our general reception help desk here and just ask them, is so-and-so in this department available to speak? And of course, we pass the call on to them, not thinking it will be a recruitment agent. And then that particular person has not necessarily liked the fact that the recruitment agent has called them. And so it's such a grey area to think about in terms of you've got the information available on social media, but for that particular contact detail in terms of telephone number or email address hasn't necessarily been disclosed. And so I think as a recruitment agent, what you need to do is really judge for yourselves whether that's the right thing to do, whether you think it's something that you should be contacting these individuals, even though they haven't necessarily given you consent to do so by including some sort of contact details online.
Right. The next point here is, like, for example, if you take me on my email address, suda@raffingers.co.uk, it's on our website, right? So basically, I've given consent for somebody to contact me, right? So what happens in that situation? Should they send an email to me and say, or have an option for me to opt out?
Yeah, definitely. So it goes back to the points that I was raising earlier with the marketing emails. What I think you should do is, if an individual has given you their email address, on the first email that you send them, give them the chance to opt in, essentially, by way of a soft opt-in in terms of them replying to you. And as you continue to send them emails, give them the chance to opt out and unsubscribe. And like I said, this could be done by including a link at the bottom of an email to basically go and click onto and then just unsubscribe from any future correspondence.
Yeah, good.
Moving on to the next slide, I just want to talk about GDPR under certain special categories. Now, if you cast your mind back right to the beginning of the webinar, we talked about GDPR for personal data and sensitive personal data. And now what we've got is something called special categories. And this is quite relevant for recruitment companies, because as a recruitment company, you're probably going to be collecting data to do with race, political views, religion, criminal records, and that sort of thing. And so this type of data actually falls into a different category known as special personal data and special categories of personal data. And now what you need to ensure is, as a recruitment firm, as you're collecting this type of data, you're meeting the conditions in order to do so. And the conditions are very similar to as they were under personal data in terms of consent and legitimate use and making sure that you're doing it as part of your performing your role. So really, I suppose the point to note here is that as a recruitment firm, you're probably going to be privy to a certain amount of personal data that other people won't be privy to. And so you need to make sure that you've got the relevant conditions in place in order for you to process that data. Moving on to the next slide, and just something that we want to talk about, hopefully very briefly. And as you can see, we've got the data subject rights up there. But I'm not going to go through all of the individual rights just because we've got them listed on the screen there. I just want to talk about 2 or 3 of the most important ones. So under GDPR, we've got these data subject rights, the rights that the data subjects have over their information. The first one is the right to access that we'll talk about. So essentially what this talks about is the type of information that the individual that you've collected data on for is entitled to actually view under GDPR. So under the GDPR, the individuals will have the right to obtain the confirmation that their data is being processed, actually access their personal data and any other supplementary information that you hold for them. So really it's quite important that really places the, I suppose, the importance on yourselves as controllers of the data to ensure that you've got the relevant communication line set up with the data subjects to ensure that they know what their data is being used for. The right to rectification actually is an interesting one, because now going forward, individuals are actually entitled to have their personal data rectified where it is inaccurate or incomplete. And this is quite important for recruitment companies. So for example, we can go back to the example I used earlier about holding someone's CV on record for say 5, 10 years or so. Now that individual, their circumstances and their data over time may have changed. So for example, their employment history. So they have the right to actually get in contact with yourselves and say, hold on a minute, that employment history has now changed and we actually want to update our CV and change our CV. So you need to make sure that you've got the right processes in place in order to do this. And the final right that I want to talk about is the right to erasure. And this is what's more commonly known as the right to be forgotten. And I suppose the broad principle underpinning this is that it really gives the individual the right to request the deletion or removal of their personal data where there is no compelling reason for its continued processing. So again, using the same example, if you've had a CV on record for 10 years and you've not used it since, and you've sent 1 or 2 communication emails back and forth to this particular individual, they have the right to come back to you and say, hold on a minute, you've not used my CV, and so therefore I really want you to remove it from the system. And an important point to note here is that you need to make sure that you engage with your software providers and I suppose your IT departments, and making sure that you actually delete this data from the front and back end of your system. So the front end being what you use every day. And in terms of the interface of the system, that's quite easy to delete the data of. However, there could be data that you store elsewhere and behind your system and in some backups and security and that sort of stuff. And you need to ensure that the data is also removed from this system.
Yeah, the key for us, I just want to pick up on a couple of ones that we are concerned as a firm as well, which is probably going to apply to a lot of you guys as well. It's the right to erasure, right? Deleting data. We use what's called the Microsoft SQL database, SQL server-based database. So the problem there is it tried to delete individuals' information is very difficult. The way our software is written, the core software is written, is very difficult. So we had to engage with the software provider to see how we can do that. So our advice to you is that you contact your the core software providers and see what they have plans for GDPR when it comes into effect, how you can delete individuals' details on a case-by-case basis, isn't it? And also the key one that Mel just mentioned is the deleting the data front end and back end. It's no good just you deleting information on the front end and then you got information the back end still out there, isn't it, for people to access?
Exactly, and you've got to think about what your back end is as well. So for example, if you collected someone's CV 10, 15 years ago and you printed it off and put it into a file, and at that time of collecting the data, you were I suppose you weren't as paperless as you are now. You could have stored this data elsewhere in some sort of archiving facility. So you need to make sure that you've gone back into that and actually got rid of that information, because essentially it puts you at risk in holding that information for a longer period of time.
The other one is data portability. You're going to have candidates' information on your PC, laptop, and you're going to walk around with it. So you have to make sure you have you have the information securely transferred from one to the other. When you're carrying a PC or laptop, make sure it's all encrypted and there's a password there. So people can't, if you lose it, people can't easily access it. If somebody wants to hack into your PC, if somebody can hack into Sony and major corporates, they're going to hack into yours. So you can't do anything about it. But at least you need to have systems in place that can't easily access it. So you need to have passwords. The other one is the carrying a memory stick. Kingston Data Traveler has got a memory stick which has got a password on there which doesn't allow you. It's encrypted. So if you lose the password, you lose the data as well. So that's a good one to look for. Kingston Data Traveler is called. It's a memory stick with a password and it's a highly secure memory stick basically. Yeah.
Moving on to the next slide, I want to talk about breach notification very briefly. A lot of the commentary around GDPR in the recent months has been focused and centered around breach notification, just because I think the penalties and fines with breaches are quite significant. So before we go into it, it's important to understand what a personal data breach is. A personal data breach means a breach of security leading to the destruction, loss, alteration, unauthorized disclosure of, or access to personal data. So you can see that a personal data breach is more than just actually losing personal data. And what's important to look at is that you have to really notify the relevant supervisory authority of a breach where it is likely to result in the risks to the rights and freedoms of individuals. So what you need to look at there is, if you've had some sort of data breach, has that posed any threat or any risk to that subject that you're holding that data for? And what's really interesting with this, that a notifiable breach has to be reported to the relevant supervisory authority, so in our case, the ICO, within 72 hours of the organization becoming aware of it. So that's important. You really need to make sure that you've got your house in order, because once you've had a breach, you need to understand what has caused that breach, where the risks are, and then on top of that, you need to make sure you're ready to go and ready to report to the ICO within 72 hours. And what's interesting now, and why there's been a lot more commentary around this, is that failing to notify a breach when required to do so can result in up to significant fines. You've got up to, I think, 10 million euros and 2% of your global turnover. So you can see that the fines and penalties around this are quite significant. So it's important to make sure that you've got your house in order to avoid a breach going forward.
This is what scares a lot of people, actually. So we on the ICO website, there's a blog there where they're saying we have a big stick, we don't want to hit you with it yet. So just bear that in mind. It's not going to come overnight, and they're going to start sending penalties for you. And the key here is repeat failure. If there's a breach there and you've put systems in place that not to happen again, then you are actually safeguarding, isn't it? That's how it works. Repeat failure is a big no-no.
Exactly, and it's interesting what Sudha talked about in terms of an overnight sort of fix. As we mentioned, GDPR comes into compliance on the 25th of May 2018. And one thing that the ICO talks about is that there is no overnight change. So it's not as if on the 26th of May, they're going to be looking at everyone to make sure they're GDPR compliant. The ICO do recognize that it will take some organizations, and especially the larger organizations, a lot more time to get their house in order, their systems and processes GDPR compliant. So, really, you need to make sure that you're getting your process and systems up to date, and you're demonstrating that to whoever it is, if it's the ICO or your stakeholders. Moving forward, we're just going to talk about in our last slide of our webinar today, before we move on to the questions, is your next steps. So this is probably the slide that you're more interested in as a recruitment company or as a recruitment agent, in terms of what can you do to get GDPR ready and GDPR compliant. I suppose the first step that I would like to start off with is looking at completing an information asset register. So that's the second bullet point on your slide. So what I think you should be looking at is actually looking to complete an information audit. And what an information audit can do is actually identify what type of data you hold, where you hold it, and who is responsible for it. So it really helps you understand your organization and where your data sits. And then once you've done that, you can then move on to completing a data protection impact assessment. And essentially what a data protection impact assessment does is it actually looks at your system and what safeguards and security you have in place to ensure that data isn't lost or misplaced. And essentially, it helps you put measures in place to protect the data and comply with GDPR. Moving on to the third point, and I suppose the third action you can do, and it's quite a relatively easy one that you can probably action straight after this webinar today, is actually train your staff on GDPR and data security. And this is something that we've taken on in our own firm quite importantly. And we've started to look at training our staff and understanding from them what we can do to make sure that we've actually got all the data secure, and really showing them the safeguards and precautions we've put in place. And what we've also looked to do is actually communicate the consequences of breaches to our staff, so they understand the severity of what is involved in here. Moving on to the next point, what we can do, and what you can do essentially is look to appoint a data protection officer. I think it's important to appoint a data protection officer. And I know for a lot of the smaller organizations out there, this is going to become quite difficult in order to do so. However, I think it's important to do it because essentially it gives you a focal point for your GDPR compliance going forward. And it really helps you understand that you've got an individual there who knows where your data is, what security you have in place, and they can really drive your GDPR plan forward. And a couple of easy wins that you can look at, and again, something you can look at before you really start to ramp up your information asset registers and your data protection impact assessments, is actually look at what you tell people, so your marketing, and how are you communicating to them, what emails are you sending out. Improve subject access procedures. So for example, the right to be forgotten, looking at making sure you've got the right avenues and channels in place where data subjects can contact you, and actually getting rid of that older data. And what's important, I know Sudha mentioned it earlier, is actually starting to review your contractual terms. So with your candidates, when you sit down with them, do you have some sort of engagement letter in place, or do you have some sort of engagement terms that you have in place to ensure that you get consent, and making sure that they are, they understand that you're going to be using their personal data. And the final point that I want to talk about is the GDPR action plan. This is a really easy win for you guys, because I think what you can do is actually go online, go onto Google and actually type in 12 steps from the ICO. And if you put 12 steps from the ICO, you'll see that they put together 12 steps that any organization can take to ensure that they get GDPR ready. And I think this should be your starting place to ensure that you've got your GDPR action plan in place.
Yeah, I just want to pick up 3 points from this list here. Point number 2, complete an asset information asset register. Basically, what that means is you need to look at where your information is held. You might have an Excel file on either Tom or Sam's machine, which has been sitting there and you haven't turned on for, few months, few years, and you've completely forgotten about it. That Excel spreadsheet's got, candidates' details. So those are the things. You need to look around your office and say, wherever you got information, you need to make sure, is it necessary to have it there? It might be something that you used 10 years ago and you haven't bothered doing anything with it. You probably have to delete all of that or secure it. So that's what you need to do, is just make sure you look at everything, where your information is, where your data is, and make a list of it, where you're holding them. The third bullet point is that training your staff. We here train our staff on money laundering. Same thing we're doing with the GDPR as well. Constantly, we'll be updating our staff once every 2 months. We are planning to update our staff every 2 months. It's a bit like our CPD. Part of that, we're going to do this as well. The seventh point is the contractual terms. I'm assuming that you all have an engagement agreement with your candidates. Make sure that includes any GDPR related items in terms of consent, using their data with other agencies. Put that on your engagement agreement with the candidates. Right, we will now go to the questions.
Yeah, so
thank you.
We've had a few questions.
We had a few questions actually already sent by some of you. So we're going to go through a few of them and then we'll go to the live questions on the screen. Right. One of the questions asked is sharing a CV with rig managers not based in Europe. So people outside Europe, you're going to share the information with them. Well, what's the answer there, Mehul? How do we do it? We can go back to the consent issue again here, isn't it?
Exactly. So what I think you need to do is there's a couple of points in terms of sharing information outside the EU. So the first point being that GDPR is an EU initiative. So you need to make sure if you're a firm within the EU, you are compliant with GDPR. So as far as I'm concerned, you still have to be compliant with GDPR. However, once you start sending information outside of the EU, you need to look at your contractual terms that you have in place with that particular organization and that particular stakeholder. So you need to make sure you have some sort of contract in place with them that is also GDPR compliant. And it's a real grey area. And I think going forward, what you should be looking at is when you get these particular arrangements, is actually to give the ICO helpline a call and actually explain it to them and get the proper advice from them to make sure that they've understood your situation and you've got the best advice. But like I said, ensuring that you're always GDPR compliant, regardless of whether you're exchanging data within the EU or outside the EU, and making sure that your contract reflects the fact that it's GDPR compliant.
Right, just going back to this again. So the key here is, the recruitment agency that you're dealing with outside the EU, they must have plans for GDPR as well. So they can't, because they can't deal with companies based in EU unless they have a GDPR plan. So even though it says within the GDPR, they should have a system, some sort of regulation that they need to follow to deal with you. That's what's good. They will be dealing with other companies as well within the EU. So you can ask them, what systems have you got in place in terms of GDPR? Because I'm sure they will, because if they're dealing with you, they will be dealing with the other recruitment agencies as well, isn't it? That's what happens.
Exactly. Yeah. So the next one we've got, and there's a couple of easy wins here in terms of questions, so I just want to cover them off very quickly, is how long can we store applicant CVs? And essentially, this is something we've touched on in our webinar. The GDPR doesn't give you any minimum or maximum period time of storing CVs. And the judgment is upon you as a firm or as an agent in particular to make sure that you look at your CV and say, okay, I placed this candidate into a role 2 years ago. Is it still relevant for me to hold that CV? Probably not. But what I will do is I'll hold their contact details and contact them every so often to ensure they're happy in their role. I think that's the approach that you should be taking. And then also moving on to storing interview feedback and notes. It's the same as what I just mentioned earlier. You need to understand from yourself as a firm whether it's relevant that you hold interview feedback and notes for 5 years. My particular sort of opinion, I don't think it is. I think what you should do is once you've placed that candidate into a role, after a couple of years of doing so, you don't necessarily need to hold all that information. You can then securely delete that information and then just hold their contact details going forward.
Yeah, on that point, if you place a candidate with an employer, and if you want to re-engage the candidate, you're going to do another interview again anyway, isn't it? So you're going to have notes there. So we're not sure whether you need to hold the candidate information, your meeting notes further than that, isn't it? More than that.
And it depends on a candidate by candidate basis. So, for example, you might have some candidates who are contractors, and that's legitimate to hold their information for a longer period of time, because you know that that particular individual will be changing job in 6 months, a year, or 2 years after their contract is finished. And so you might want to hold those interview notes on file because you don't want to necessarily cover old ground with them. So as long as you've got a particular compelling reason in order to hold that information, I think it's important you demonstrate that reason, and you should be okay going forward. And another question that we've just had, which is a very interesting question and something that we've thought about internally, is when you actually have that candidate's details and all their data that you've collected from them, can you share that data internally? And this is where I think it comes down to your contract and what you've really agreed with the candidate. And as part of the performance of your contract for that candidate, and this being looking for a job for them, you have the legitimate interest to ensure that you share that data internally. So as far as I'm concerned, once they've given you the go-ahead and they're engaging not necessarily with the agent, they're engaging with the agent and the recruitment firm itself. And so therefore it's not untoward where you can say, you know what, I've got your details on file here, I'm going to look for a job for you, but then I've also got one of my colleagues who's experienced in this particular sector, and he will also look for a job for you as well. So I think it's important to understand that once you've engaged with the individual, they've engaged with you as a recruitment agent, but they've also engaged with you as a firm, and they're given the consent to the firm to share that data and look for a job for them.
Yeah, just to go back, I mean, if you're sharing information about a candidate within the firm, within your company, it's part of the performance of contract, isn't it? Because you're doing as part of the performance contract, right? Okay.
Yeah, that's perfect. And then again, we've got a couple of questions here, and they're all very similar in nature in terms of when you're dealing with candidates' personal data. So we've got a couple of things here about passport details and utility bills. So when you're doing a due diligence check on a client, I think we've got a question here. And now, essentially, this is, again, a very, very similar answer that I'm going to be giving. I feel like I'm sounding the same with a similar answer.
Repeating it, yeah.
Yeah, it's important that what you do is, once you've placed that candidate into a role and you've done that due diligence check, and we do the same on our side, we do money laundering checks on our clients, and we have smart searches done by Experian. And what we do is essentially, we will, because we're engaging with the client on a yearly basis as a firm of accountants and tax advisors, it's legitimate for us to hold that information. However, for you guys as recruitment agents, you might only put that individual into a job once. And if it's not a contractor, you might not necessarily act for them for another 2, 3, 4, 5 years. And so after a couple of years of acting for that candidate, I think it's quite reasonable to then say, you know what, I don't need to hold this passport or this utility bill on file. I've been given the comfort when I placed them in that role at the time that, you know, we've done the appropriate due diligence. And so therefore I can securely delete this information and continue to just hold their contact details, email address, telephone number. Moving on to the next question, references and actually getting in contact with referees. Now, what you can do, I think with this especially, is you're going to get the references and the referee details from the candidate itself. And when the candidate is then passing you on their personal details, they would have spoken to that reference or spoken to that referee and said, look, hold on a minute, I'm going for a new job, will you be willing to vouch for me? And that individual willing to vouch for them is giving them consent. And once they pass those details on to you, that's them giving you consent to contact that referee or reference. And so essentially, as long as you have something on file to demonstrate, be it an email, and if you record your calls, be it a phone conversation to say, you can contact these individuals, and normally it would be by way of email. They will give you their details over email and say, please, can you contact these individuals to obtain a reference? So as far as I'm concerned, as long as the candidate has given you consent, and they have by passing those details on to you, in order to contact those references and referees, you should be covered.
Yeah, I've got another one here, updated consent. If the database you use doesn't keep record of whatever your interactions have been interacted with by the individual. So basically what it's asking is that you had consent before, but you haven't got no record of it. Can we contact them again? We have this problem within our firm. What we're doing is actually we are doing this again. So we are asking for consent again. We just kind of explained to, with an email, we're explaining to our contact saying, you know, because of GDPR, things are changing. We need to update our records. So can you give us consent again? So we are actually doing that ourselves. I think it's best practice for you to do the same thing because you haven't got a record of having consent in the first place anyway. So you need to get one. So you need to keep a record of it, right?
Exactly. And then the next question we've got here is how do we go on with company phones, mobile phones, and telephone and email addresses of candidates and that sort of thing. So I think this comes back down to where I talked about the different types of data where you hold them. So if you have an individual, and so I'm talking individual, be it a John Smith, for example, and if you've got his personal email address and his personal telephone number, that constitutes personal data and is picked up by GDPR. And so therefore you need to make sure that you have the relevant safeguards and measures in place to protect his or her data. And then when you've got telephone numbers and email addresses of candidates, and say, for example, they are their work telephone numbers, so their work number or their work email address, there is nothing in GDPR to say that it applies to them. However, as I mentioned in the webinar, I think the best practice to follow here is you treat it as you would with the individual's data. You still have the relevant safeguards and precautions in place to protect that individual's company telephone number and company email address, and making sure that you've got the right security in place to ensure it doesn't get in the wrong hands, basically. I think the next question, which is an interesting question, we're getting a lot of similar questions to what we've just mentioned in our webinar. So it is quite interesting that we're actually talking and thinking about the topics around this. And the next question is, do we need written consent to hold or process candidate data, or can they click on an opt-in on our website? So essentially, the way I see that is, we talked about the marketing side of things when you send out an email. So just a repeat of that would be making sure you ask them to opt in at the very beginning, getting that soft opt-in, and as you go forward, giving them the option to opt out or unsubscribe on emails. Maybe it's a disclaimer at the bottom. Now, with the website and the way that works, when the individual goes onto the website, they can click onto a link, fill in their personal details on the website. What I think you should do is have some sort of opt-in box at the bottom, and have that box to be a tick box or some sort of confirmation that they can make on your website to say, can they be contacted and their personal data be used going forward? As long as they can do that on your website and they can tick through that, and then what you guys need to do as recruitment agents is actually show record of that. So once they've ticked that, you've got some part of your back end of your system which can run a report to show that all these individuals have ticked to say that they've provided us consent to use their personal data going forward. As long as you can demonstrate that you've got that consent and you can see that from your website, then I think you're okay to go ahead and use their personal data going forward.
Another question here, if an individual sends you their CV for a job, do you need to email them back something that asks for consent? I think what you need to do here is, somebody sends you an email, somebody sends you a CV. The best practice, as we said earlier on, is have an engagement agreement with that candidate. Send an engagement agreement with the candidate. To ask them for basically a consent to use their CV. You want to share it with websites like Indeed and places like that, isn't it? That's the best thing. So when a candidate sends you a CV, do an engagement agreement with them. These are the things that we're going to use. Ask them to agree, then you're covered. That's what you're trying to do here. You're covering yourself, basically. Isn't it?
And what I think is important, I know Sudha mentioned the engagement agreement. Now, what I don't want to do is put a great deal of stress on everyone, say, oh, we've got to get some sort of big agreement in place. That engagement agreement can be relatively simple. You can just reply to their email and say, look, I've received your CV. Thank you very much. Can you just confirm that you are happy for us to use your CV and your personal data in order for us to look for a role for you? And as long as that individual then replies with a yes, we're happy to do so, and you can then take that email and then store it somewhere and have a record of that email to show that you've got that consent, I think that's pretty legitimate. And really at the end of the day, it's in your interest and part of your performance of your contract to use their personal data. So just literally having that yes on an email and you can go ahead, that's proving consent. So I think that's pretty straightforward.
There's a question about deleting, erasing data. How to deal with this when most candidate data is shared with third parties? That's a very good question. How do we deal with it? I mean, we don't have that kind of situation. What happens is this is the problem with the front end and the back end, right? So you're actually deleting information on your database. What happens to the other people, the people who are holding the same information? If they got the information through you, you need to inform them to delete as well. That's right, isn't it?
Yeah, it really comes down to this point of controllers and processes.
Yeah.
So let's think of a scenario here. You're a recruitment company. You've obtained an individual candidate who's come into the office to see you and wants to look for a new job. They've given you their CV and shared their information with you. You've then passed that information and that CV onto a third party to, in order to help to look for a job. And then say you found them a job, 2 years later, they come back to you and say, look, by the way, I've seen my CV on someone's website, or I found that my data is stored elsewhere. Now, what you need to do in that point is that you collected the data originally. You were the controller of that data, and then you passed it on to a processor of the data, that third party. So the onus is on you. So there's a couple of points we need to be picking up here. Firstly, you need to make sure that you've got a contract in place between yourself as the controller and the processor, the third party that is GDPR compliant. Secondly, what you need to do is when that individual asks you to get rid of that data, you need to make sure it's all gone from your system, which I believe you can show and demonstrate you've done that. And then secondly, what you need to do is contact that third party and say to them, look, we've been informed by so-and-so individual that we need to get rid of their data. As we passed you the data in the first place, we want you to get rid of that data from your system. And that is the most, I suppose, the most efficient way to do it, is ensuring that you're communicating with your third parties regularly to ensure that the data is kept most up to date. And I suppose one of the key points that this is going to lead to, especially in the next couple of years, is that a lot of firms are going to start to cleanse their data that they hold, because they're going to see that holding all this data poses a greater risk and a greater threat to them. And so therefore, you're going to see a lot of cleansing of data and a lot of firms becoming more efficient in terms of the type of data they hold there.
Yeah, as Mehul said, the third parties that you're going to deal with, you are dealing with, they should be GDPR compliant as well. Also, you need to keep a record of who candidates' data that you ask these third parties to delete. I'm assuming you're all using a CRM package or a package that allows you to put these sort of notes to say, Sudha asked his data to be deleted from your database, or you informed A, B, and C who also holds Sudha's information. That's what you need to do with that, right?
Yes. So just a quick one. We've got another question here, and this is quite an interesting one because it's something we thought about internally. Can we send emails to all our candidates to ask for consent? Now, you're going to have, say, for example, 200, 300, 400 candidates. Now, I don't think there's anything wrong in sending all your candidates an email and saying, look, guys, there's a new regulation out in terms of data protection. We just need you guys to confirm whether you're happy for us to continue to send emails. And the risk, I suppose, you pose there is you're going to send emails, and a lot of people won't necessarily read their emails, and a lot of people won't necessarily come back and agree to that. So what you might end up doing is actually shrinking your marketing database, if you want to call it that, from, say, 500 individuals to a couple of hundred. And so as a firm, you really need to think about what you want to approach and how you want to do it. Because if you do go down the route of sending out one big email and an email en masse, you could run the risk of actually shrinking your candidate database. And so therefore, what I think you should do, in my personal opinion, is the way you should kick this process off is actually by starting and going through your candidate database, because at some point that candidate would have given you consent when you first engaged with them in order to use their personal data. So you wouldn't necessarily have to re-engage with them to get that consent again, because you've already got it in the first place. And I think that way is a lot more better, because that, I suppose, mitigates the risk in you shrinking your candidate database going forward.
Right, I've got another question here. Do we need to contact all candidates which we currently have on our database for consent? Yes, if you don't have consent already, yes, you have to contact all of them if you haven't got consent already. We did go through this earlier.
Yeah, so just this is a repeat of the same question, really. And like I said, if you haven't got anything to demonstrate consent on your system, so like I said, we wouldn't necessarily send out an email en masse to everyone to start with. What I would do is just run through your database and check whether you've got some sort of email correspondence with them or some sort of contract with them to say that you can use that their personal data. And if you can't demonstrate you've got nothing, then the second step would be to email them, as Sudha says, to email them and get that sort of consent.
Each recruiter has, I've got another question here. Each recruiter has their own database. Is there a way to keep their details in case they contact the company in the future? So this is basically about keeping data for how long, right? Ownership.
Yeah, so
same thing again.
Yeah, so yeah, just looking at this, it looks like so what we've got here is there a way to keep their details in case they contact the company in the future, so that we can keep track of a candidate ownership within the team. And then essentially what you've got to look at here is where you're passing your data. It's quite a grey area. So like I said, if we just think about an example here, if you've collected that candidate data in the first place and then you've passed it on to a third party, you are the original owner of that data. You are the controller of that data. When you pass that candidate data onto a third party, as long as you've got consent from the individual, firstly, that you're happy, that they're happy for you to pass that information onto a third party, then that slightly mitigates your risk. However, I can see that the ICO would look at this as a controller and a processor relationship, and the third party being the processor. And essentially what you need to do is make sure that at that point, if the individual then comes back into you and says, hold on a minute, I want to get rid of my data, or I want you to remove my data, not just necessarily from your system, but from another person's system, because I'm starting to receive emails from that other third party about jobs. And so what you need to do is get in contact with that third party and say to them, we originally passed you these details as part of this agreement. However, the candidate and the individual has come back to us and said to remove the details, and so therefore we want you to remove their details from your system as well. And so it really comes down to the ownership of the data and making sure that you see your, I suppose, your responsibilities through as a controller of the data.
Okay, I've got a question from Amy here. I can't read it on the screen, but we will come back to you, and we will send you an email. We'll read it. We'll send you a reply to you, and we'll actually put that on our Q&As. We'll put that on our Q&As on our website. You can have a look at it. There's a lot in there, Amy. I can't actually read all of it from here, but I will actually come back to you, and we'll put it on our website as a Q&A, isn't it?
What we'll do is we'll send you an email if it's easier, just to respond to that question, because there's quite a few things in there, and an example that I think you've given. So we're probably best that we come back to you on an email on that.
Yeah. That's it for today. Basically, we're running out of time. Thank you for joining us. Just to summarize what we actually went through, and for you to take from this is, main thing is do a data audit. This should be an urgent priority for you. Just to elaborate on what a data audit is basically you're assessing how your data is fit for the purpose of your business. That's what you're doing. You're assessing, is the data you're holding is fit for the purpose of your business. That's what you need to do. That's the first step you need to do. So do that, and just remember, there's a lot of uncertainty going on. 100% compliance is going to be very unlikely and unrealistic. On the 28th of May 2018, nobody's going to expect everybody to be compliant, right? It's going to be very unrealistic, right? So take the steps to get there, and hopefully, you can get there. Thank you for joining, and we hope to see you soon. Thank you.